A few familiar faces, so nice to see you all again, and for those, nice to meet you. Just before we get into the nitty-gritty of some of the regional labour standards text and documents that we're seeing across the region, I've just got a few notes from the previous two presentations, which, thank you, that really sets the scene really well. But firstly, what are labour standards? They're a bit difficult to define. But however, from my side, not from a law or policy type angle, but labour standards are a reflection of our values. That it's what we're saying is acceptable for our people and migrants to experience in the world of work. It is directly our values, and yes, we can be guided by best practice and science and that type of thing, but ultimately it boils down to what we stand for as people and as a state. So as we've heard, there has been a bit of a link to transnational crime, IUU fishing and climate change. They are all recognised links, that where there are transnational crimes such as drug smuggling, there is more likely to be decent work deficits or human trafficking. Where there's IUU fishing, we see more decent work deficits. And as the climate changes, we see more decent work deficits, not only in fishing, but across a large number of sectors. We've heard about representation, which I'll touch on a bit throughout this one. But while you're thinking of this, take your fisheries hats off. Have one lens of fisheries on, but thinking about the people. Just touching on some of those roles of enforcement officers. One vessel, while I was doing an inspection with the New Zealand government, they came on and the crazy skipper that I had the displeasure of working with decided to scale the mast with no safety equipment. He just climbed on up to point the VMS units out. I almost threw myself in the ocean. It was just terrifying of, oh no, we've got enforcement officers on board. And they just go, oh no, we don't look at health and safety. Which, to me, is, again, that appalling silo that shouldn't exist. Labour's across the board. It's not up to any one administration to keep people safe. It's everyone's responsibility. Of course, we need to think about a recruitment shortage in fishing as well. Why don't people want to go to sea like they used to? Again, a New Zealand example, back in the 70s and 80s, you had to fight to get on these large factory trawlers. You had to know someone to be able to get on board. They had lines out the door. And now they can barely crew them fully. The likes of C188 and hearing that Spain has ratified C188 and it's finally come into force only a few months ago. In the WCPO context, it's about 4 vessels, which C188 is applying to. We're seeing a lot of the movement of people, and that's one issue that seems to be missed out in both these regional tools that we'll touch into. I was lucky to join one FFA member country to just shadow them and observe some inspections and see how the human element of inspections could fit in. There was a crew transfer while that vessel was coming from the Solomon Islands to Suva. It was written in the logbook in Chinese. The vessel agent did the verbal translation, but there was no verification of where this person went to. It was just, oh yeah, they got transferred to another boat, and that was it. Hearing some of those kind of stresses as well, what's affecting the industry, and one thing on the industry not trusting, the fishers not trusting government, is that over-regulation. There was a psychosocial study done largely coastal and recognising it was a poor sample size, but the key stressor that they found through the psychosocial assessment was the fishers felt they were over-regulated. The likes of the Cape Town Agreement, 2 FFA member countries, 2 Pacific Island countries have ratified that, Cook's and New Zealand. STCWF is only 4, Kiribati, Nauru, New Zealand and Palau. So the international conventions that are being made aren't quite trickling to our part of the world, and we're seeing that with C188 too, with no ratification, while there are some working towards that. Silos, silos, silos. We're always going to hear about them both at the international, the regional, and the national levels. And of course, it's quite important to bear in mind the fleet makeup in the Pacific. While we can talk about the national labour standards of our Pacific Island countries, 80% of the vessels fishing in the Pacific Ocean, or Western Central Pacific, are foreign flagged. So the Pacific Island countries have very little to do with that. There are ways around that. So some of the kind of key issues in labour standards, starting from kind of the worst, is forced labour and human trafficking. More common around migrants. The exploitation of migrant workers, unsafe working conditions, long hours and inadequate rest, lack of access to legal protections, which we've already heard on, so I'll kind of skip over this. Some of the other kind of things that we're touching in as we look to regulate labour: health and safety through vessel safety, health and safety for people, living conditions, recruitment, work conditions, the additionally vulnerable such as migrants and children, representation, freedom of association, unionisation, representation not just of fishers but of industry as well. And one thing that I really do believe that is being skipped is the well-being, that mental health, both the isolation that they're facing but also the social isolation. They're living with a handful of other people for long periods of time. They're not getting that worldly experience of different faces, different beliefs. So what are some of the challenges? That difference between domestic and foreign flag vessels. We're seeing some really great work in some countries, but that's largely on the domestic fleet. There is less thought being put into the foreign vessels coming and using their ports. The role of crew providers, and from the outset I hate the term crew providers because it doesn't humanise. They're not providing crew, they're arranging for people to get jobs. They're a recruitment agency, they're not providing them. So kind of thinking to the bigger picture of migrant workers, and I was fortunate enough a few months ago to join a high-level dialogue, a tripartite high-level dialogue on the 2050 strategy and decent work. A lot of that was on labour mobility and labour migration. But fishing wasn't thought about because it was the thought of us as Pacific Island countries are labour sending states more than, but in fishing, we're labour receiving. So while we're talking about all of our seasonal workers going to New Zealand and Australia, so on and so forth, we're not thinking about the migrants that are coming in country. That was really interesting to hear some of the chambers of commerce address that, particularly the Cook Islands Chamber of Commerce was saying how they're not really a sending state, they're more receiving across the board. The different roles of flag, port and coastal states in the Pacific, with largely foreign boats coming in, we're limited as far as our flag state role. But as port and coastal states, we've got a huge role to play. How does that work for regulation? How does that work for monitoring? Interagency, collaboration and cooperation. Again, we've got international level, regional, sub-regional and national. Are they talking to one another? Why is this not progressing as quickly as it could? Make safe arrangements. This is a hard one. When a vessel is at sea and they're boarded at sea, what can the enforcement officers do to make the person who is being mistreated safe in the immediate, without affecting the manning of the vessel, so on and so forth? It's not like a factory on land where they can just go in and get the worker out of there. We've heard on the international conventions, where is the representation of fishers? And this was something I noticed in looking back on some of the C188 development, is yes, it was tripartite, which is great, but lots of the expertise from industry and from fishing was more seafarer knowledge than specific fisheries knowledge. And that, again, the lack of representation of fishers and fishing industry, those that really know about that. And again, that shipping versus fishing safety, there is that imbalance. When it comes to the representation, and I think that might trickle through, as an example, the Seafarers Union in New Zealand was trying to bring fishers into it. And the fishers threw their arms up and went, no, we're completely different from you. So that's kind of bitten them in the backside. But looking at the HMTCs, FFA's HMTCs are harmonised minimum terms and conditions for access by fishing vessels. It is a non-binding document that is agreed by 17 member countries. The standard is that it applies to foreign vessels only. However, at the ministerial level, they can choose to apply to the domestic fleets, which is what they did with the crew and employment conditions back in 2019. The way it's written is it's the responsibility of the owner, but it's the members' obligation to implement that. So the HMTCs, and I'll just kind of cover the key points. I've put each individual point of the HMTCs in here. The responsibility for health, welfare, safety of crew while they're on the vessel for the duration. That a written contract, terms of employment is present, and that it meets the minimum set out in Annex 6, which is, again, very basic. That they shall observe and respect any form of basic human right in line with international standards, that they take all reasonable steps to ensure that crew are not assaulted, so on and so forth, that they're responsible for the provision for any health protection, management of sickness, injury, death, while employed or engaged. Medical care shall be provided free of charge to the crew. In the event of death, they need to notify the relevant authorities as soon as possible and ensure the body is well preserved so they can take it to port for investigation. They're responsible for advising the next of kin. They shall provide a decent and regular remuneration. They provide repatriation to the crew when the contract's terminated with the relevant points. Periods of rest, sufficient length, not quantified like C188, and that was the concern of some of the membership while they developed this. And it is worth noting that this is very similar to C188. They used it, but they scaled it back. That they need to ensure that the vessel is safe. The safety of the crew is taken care of through training. And what they need to provide to the crew at no cost. So travel costs, insurance coverage, copy of the insurance policy, adequate safety equipment and tools like PPE, accommodation, which is clean, tidy, decent, sanitary facilities, which are hygienic and decent, and suitable food and water. Both the adequate quantity, but also meeting health and religious requirements. They prohibit the deduction from crew wages by any party for any expenses related to work. That one's really targeted at some of the billing that's done by recruitment agencies who shouldn't be doing that. So where are the HMTCs at? Yes, this was agreed back in May 2019, so over 5 years down the track. 4 FFA members, Tokelau, Tuvalu, PNG and Palau, have implemented either through regulation or licence condition. Fiji and Solomon Islands have approved government policies to implement, which includes putting the HMTCs in, but a range of other activities. And most other FFA members have started the work to implement, but progress is slow. This is largely due to the need to raise the capacity of FFA members. And I want to be clear that FFA members, in this case, are the fisheries officials. The FFA Secretariat supports the FFA members, which is fisheries. While they represent their country, it is the fisheries administrations. Fisheries officials have never looked at labour like this before. So there's a lot of education and training that needs to go on so they can understand what they're regulating, what they're monitoring, what they're enforcing. But because they haven't done this, there's also a lot of work going in to make sure that the different agencies that need to be in the room are, and that they have the relevant tools that they can work together, like MOUs, so on and so forth. The HMTCs, I think it's really important to note, they are the lowest bar that is set. And in my personal opinion, now that I'm independent I can say these things, my personal opinion is that they can do more harm than good in some ways because they are setting a minimum, they are setting a bar, full stop. People aren't working to be above the bar, they're working to meet the level of the bar, and that's not there yet. Like any regional or international agreement, these documents are diluted because you've got to get consensus, and that takes time and concessions. On the bigger scale, outside of the EEZs, there's WCPFC Draft CMM, which kind of started back in 2018 with the endorsement of Resolution 2018-01 on labour standards for fishing crew. This was really pushed by Indonesia, initially proposed by them, which the FFA members got on board with. From 2020 to 2024, there's been a lot of intersessional work to develop a measure. Prior to that, there was a lot of concern from WCPFC CMMs, a small number, that is this the role of fisheries agencies? Is this the role of the Commission to regulate decent work? It was determined it was, thankfully. So the text of the measure, where it applies. At the moment, and noting that none of this is agreed yet, it's going to Commission next week, vessels exclusively on the high seas. Vessels on the high seas and in coastal state EEZs, or vessels fishing in 2 or more coastal states. Then the general blah blah of nothing shall prejudice the relevant CMs on doing their own thing, that they're encouraged to do this. So, with the measure taking effect in patches across the region, what is the monitoring and enforcement jurisdiction that needs to be thought of? If you've got a crew complaint who isn't sitting there looking at a GPS going, well, I was assaulted here or this happened here, how can you actually monitor and enforce the rules that you're setting? Who will be protected by this measure? Well, the measure states all fishers. What about those where the gap is left? And there is, throughout the measure, huge gaps. These are basic human rights, that you do not get assaulted, that you do not get beaten, that you do not get killed. They're basic, they're fundamental rights of labour, that you're not discriminated against, that you're free to associate, you're free to unionise. You have a right to be bloody well paid. So why has the Commission picked only a part of the region? Human rights are universal and inalienable. They apply everywhere. Deeper in the text of the measure, there's key ones that are almost in opposition to universally agreed human rights, like the Conventions for the Rights of Child. But the Commission is looking the other way. In the minimum working conditions, very similar to 188, very similar to the HMTCs, safe working environment, welfare, occupational safety and health, no forced or compulsory labour, which is already a fundamental principle, providing in terms of employment. There's all the jargon, noting attachment 1, which we'll get to later. Decent working and living conditions on board. Decent and regular remuneration. Regular opportunity to disembark within the laws of the flag CCM. Transportation and other related expenses. But you've got some countries saying where the early termination of the contract is sought by the owner or operator, except in cases of the crew member's breach of contract. So they'd just drop them on one of our islands and leave them there with no access to their funding, nothing. And that they require the owners and operators to carry aboard a record of provided contact details of each crew member's next of kin or designated contact person. There's nothing about requiring that for the crew though. And that they provide onboard safety training with consideration given to relative international guidelines and standards for the training of fishers. Jumping back to STCWF, being the international standard for the training of fishers, the Pacific hasn't really ratified this. A number of other CCMs haven't. So why do they need to give consideration to it? They should be required to teach to that standard. So broad areas that are largely covered by international standards, like forced labour is banned. We all know this. The terms of employment. It requires that there is a terms of employment, but not what is in it. That standard has just been diluted down and down and down. Do you even need to have the name of the crew member, or do you just have a one-page document saying we'll pay you once in a while, sign here? Decent living and working conditions. There is no definition of this, and neither is there for the HMTCs. However, at the MCS working group earlier this year, we did get the living condition quantification to be completed over the 12-month period. So, what is decent living and working conditions? Who gets to decide that? Is it the flag state, who, as we already heard, the flag states aren't doing anything to do this? Data. What data will be collected from this? We need data to ensure that we are continually improving. But certain CCMs do not want the data collected because data creates transparency, which means they're held to account, and it's actually going to be exposed on what they're seeing. Crew providers. I haven't included the text from the measure, but there has been a discussion and proposals from CCMs specifying the role of crew providers. The proposals have largely, in my eyes, been a cop-out of, well, we hire another country's private company to do this for us, but we can't actually do anything about that. In my eyes, it's the responsibility of the owner-operator of the vessel. If you're hiring from a crew provider that engages in slave labour or poor working conditions, you're the benefiting party. It's your responsibility to hold them to account as well. So some of those key questions are relating to, they don't have contracts with the owner-operator of the vessel. It's all through a third party. And what are the abilities of CCMs to regulate foreign private companies? With the current text that they do have in there, what I believe we'll see is a large number of the poor operators, instead of hiring crew from Indonesia, which is the largest percentage of crew in the region, they'll start moving to a member that is a country that is not a party to the WCPFC convention, which then the terms of WCPFC, CMM are effectively useless. What to do in the state of a crew death? Through a number of other kind of conventions and guidelines and domestic laws, there are already a lot of measures on what this is. In the event a crew member dies, you need to stop fishing, you need to go to port, you need to cooperate with investigation. Bodies of the deceased crew should not be buried at sea or disposed of in a manner unless specifically authorised by the flag, CCM's national regulation, or the next of kin. So if it's the flag state CCM goes, yeah, it's fine to dump this body overboard, you don't actually need to talk to the family, because either one can choose. Why is a serious injury in question? There are already, through usually Maritime and Seafarer Act, so on and so forth, there are requirements for notifiable incidents. But why has WCPFC gone on a different avenue? Crew missing. Again, you need to stop fishing, you need to notify the responsible rescue coordination centre, you need to follow all these steps, cooperate in search and rescue, provide a report about the incident, notify the next of kin. In my opinion, to that first question of is this procedure practical? To me, no, it's not. If a crew member's missing, presumed fallen overboard, there's so many different layers to that in my eyes, that procedure doesn't cover it. at all times you don't always need to notify RCC. If you can see the crew member over there, you might not even need to stop fishing. Strategically though, this is aligned with the Observer Safety CMM, and having the kind of similar conventions lining up does make sense. But the more overarching question, who in the room, when these decisions are being made, has actually spent time on fishing vessels? When I've looked around the room at a number of these meetings, quite a few of them it's been Francisco and myself. And that's it. And we've rattled on, probably more than anyone wants us to, on what we've actually experienced having spent considerable times at sea. But we have policy people who've stepped on a purseiner once or twice in their career going, no, it needs to be in line with this other CMM. Which it doesn't. That again is that representation. Why is policy being pushed through without the people that it actually affects being consulted, without the experts on the issue being consulted? In the event of forced labour, you need to stop it. Take action to preserve the safety of the crew. Provide Flag CCM's designated authority with a report, facilitate safe disembarkation, cooperates fully in all investigations. This one, while it says compulsory labour and other mistreatment, the compulsory labour definition is that of ILOs. Other mistreatment is defined as anything else in the measure that isn't compulsory or forced labour. There are already protocols for this. This measure, though, has been negotiated and developed by fisheries officials. Lots of them do not have the expertise in labour, in trafficking, and those mechanisms that come with that area. These largely fall to immigration departments and those that are lead on trafficking. They're already looking for some of this when they go on board the vessels, but there isn't that communication between agencies. So while I believe fisheries should be looking at this, they need to recognise their role in this space. Everyone has a part to play, but at different levels. Again, we're seeing some really crazy suggestions coming up from certain countries that after a crew gets off a vessel in a port state and they report mistreatment, we've got some countries saying with reasonable grounds or supporting information. In what criminal area, if you're assaulted and you go to the police saying, hello, I was assaulted, are they meant to go, well, prove it? Why is this even being considered for fishers? Throughout here, we're not really seeing these reporting elements coming through. So we're regulating. In my eyes, it's not effective regulation. Whose responsibility is this within the flag state? Is it with fisheries? Because that ultimately is a fisheries conservation management measure. It's through a fisheries convention. But they have a limited role to play in this. They need to be working across their agencies. How will the flag CCMs monitor this when lots of these vessels aren't even going to their flag states? Is reasonable grounds and evidence the responsibility of the state or the fisher to investigate? I think I've probably made my point far too clear on that one. Of course, because it's a WCPFC measure, there is the consideration of small island developing states and their additional need. So it's just saying that developed CCMs are encouraged to make efforts to support developing. That if they want to provide crew to fisheries, but not currently members, they should become cooperating non-members, and within 1 month after the entry into force, the CCM should inform the Secretariat of its designated contact point, because it may be different. Again, it's not solely a fisheries issue. Does the measure actually cover the needs of SIDS as the key port? Oh, sorry, port, not pot. Port and coastal states. And are the developed countries holding up their side? And Francisco already used this example, but we've got vessels going into Hawaii who aren't giving their crew the regular opportunity to disembark. They have to stand on the painted lines on the wharf. But we are seeing that CCMs, like the United States, are taking a very high and mighty approach to this. Reporting. That's all the text of reporting, the red being the proposed text. In part 2 of their annual report, they need a report on the implementation, which the co-chairs, and very fortunately the New Zealand co-chair of the Intersessional Working Group, used to work for a number of years for MFAT's human rights section. So she's been such a valuable resource in this development. So this includes the report on the implementation of obligations for crew death, missing or overboard, allegations of forced compulsory labour, and port CCMs to report what they're doing, what mechanisms they're setting up. Again, this isn't reporting the actual numbers. This isn't reporting what the issues are, so we can work to improve them or regulate further as needed. These are just going, if a crew member dies, this is what we're going to say we'll do. And the measure will take effect in 2026, maybe 2028. Again, that's up for question. From a workshop held actually in this very room a few months ago, it was kind of determined that across the government, we had a number of government departments come in. Across them, most of the measure was actually already in place for their domestic vessels as their flag state responsibilities. But that hadn't been translated until then to the fisheries officials because it's government-wide. How can reporting be improved? Other questions are, who should the reporting be open to? Should it be open, should it be going to international organisations like FAO, ILO, IMO, so they can look at their joint working group? Should it be open to NGOs? Because that's where a large amount of the political will for the labour standards on fishing vessels movement in the Pacific has come from, is all NGO report. Why aren't we working to collect more data? And that's a failure on everyone's part. We know that these issues are happening, but we don't know how bad. And how long will it take to implement effectively? None of this groundwork has been laid yet. So the attachment 1, this is what may be in a terms of employment. It has no requirement of what shall be, but may be. So we're seeing names, date of birth, vessel, so on, so forth, right through to termination, just your standard contract ones. In the voluntary, we've got the full protection and health and safety and morals of young crew members, young being below the age of 18, but this isn't actually defined in the measure, including ensuring that young crew members have received adequate specific instruction or vocational training and have completed basic sea safety training. Well, in both STCW, which is ratified by all Pacific countries, and they use to inform the Seafarer Acts, pre-sea safety training is a requirement, even though that's not actually being monitored. But why is that a voluntary one? The Convention for the Rights of Child, which is a universally accepted and endorsed human rights convention, makes it very clear that people below the age of 18 need to be protected and should not be working in hazardous work. Why are these 20 requirements not binding? It's ridiculous. And why are the rights of child voluntary? While it's been 4 years of developing this measure, why has it just been the fisheries officials, up until I think it was July this year, sitting in the room, discussing how it should be? Why aren't there government-wide ones? One that was raised on the role of the port state was, this is a disproportionate burden to SIDS, even though that is in line with conventions and protocols that had been signed by the country that raised that. So the left hand isn't talking to the right hand. And that's, I'll finish very quickly. That's the main thing I'd probably say from the regional Labour side is, yes, these are a start, which is great. You've got to get the wheel moving at some stage. But will these be adopted and then sit there as a very low bar for decades, with everyone patting themselves on the back as being the first RFMO to adopt a measure? Will the HMTCs ever be fully implemented? And why aren't all the agencies working together on this? And that's not just a failure of fisheries, that's across the board, but we're seeing some progress being made. Like MIMRA in the Marshall Islands has been put on the Human Trafficking Task Force in their country, and the work that Dan and stuff will touch on next. There is work being made, and of course Solomon's too, recognise you guys. But yeah, there is work, but there's still a lot more to go. Should it be put in place now? Well, should a bit of time be taken to actually ensure that it's right the first time? Because we may never get the opportunity to discuss a CMM at the Western Central Pacific Fisheries Commission for crew safety. Again, thank you.